everyone. My name is Dustin Saldarriaga. I am a senior associate with Scott Legal PC here in New York City. And today we're going to be talking about employment-based green cards, and in particular, the EB1, EB2, both PERM and National Interest Waiver, and EB3. With a particular focus on the PERM process. We are very fortunate to have our managing partner, LeGrand Weiner, here to present today. Kelly's going to be drawing from her extensive experience helping clients navigate these options. So we're very fortunate to have her. A few housekeeping items before we get started. If you have a question, please do send those to us using either the chat function or the Q&A function on Zoom. I will be actively monitoring those, and we do plan to get through all of the questions by the end of the presentation. I'll probably save them for the end, but please don't hesitate to send in any questions, and we'll get to those. We do webinars regularly, and we're very proud to put high quality free information out to the public. So our webinars are a main way that we do that. After this presentation, we'll be sending you an email where you can sign up for our future webinars. And those do cover a variety of topics related to U.S. immigration. Our firm does focus on business immigration in the U.S. However, we handle the full spectrum of immigration cases. So that includes temporary visitor visas. It includes temporary business visas, including the E2. It includes family-based green card options, as well as humanitarian options. So we do hope you'll check out our future webinars as well as our website, where we have our blog, and our YouTube channel. So this webinar is being recorded, and we post our full-length webinars on our YouTube channel. So if you aren't able to make one in person, do check out our YouTube channel. In addition to the full-length webinars, we post shorter videos to our YouTube channel. And again, those cover a variety of topics. With that, I am going to go ahead and pass it off to Kelly, who will talk to us about the employment-based green card options.
Thank you, Dustin. Perfect. So we're going to get started just talking about some of the, basic employment-based green card options in the U.S. As Dustin mentioned, we'll in particular be focusing on kind of the EB2 and EB3 and PERM in this presentation, although we do have other presentations where we focus on some of the other categories that are going to be briefly mentioned here. One, we have the EB1A extraordinary ability. So this is for people who have kind of risen to the very top of their field and are one of a small percentage of people to have achieved, a level of kind of sustained national or international acclaim in their field. So generally the way you qualify for this is either, one major award like a Nobel Prize, a Pulitzer Prize, an Oscar, or much more commonly, you meet kind of 3 out of 10 criteria that are all related to proving that extraordinary ability. So things like internationally or nationally recognized prizes or awards, original contributions of major significance, a high salary in relation to others in your field, kind of information or articles about you in major media or in scholarly publications, or if you've written, publications that have had kind of a broad impact on the field. So that's kind of the extraordinary ability category. There's also EB1B. This is for outstanding researchers and professors, so often used kind of in the university context for people that are coming, to kind of work in tenured positions in universities or as researchers. The EB1C, multinational manager or executive. So this you very commonly see maybe people that come on an L1A as an executive or manager, or sometimes even as an E2 executive or manager, may switch to this EB1C, where basically you're being transferred from a company abroad where you worked in a managerial or executive role, and now you're coming to a related company in the US to serve as a manager or executive. We have the EB2. So the threshold requirement for the EB2 is that you have either an advanced degree, meaning a U.S. master's degree or equivalent or higher, or you have exceptional ability in your field. An exceptional ability is kind of a slightly lower standard than extraordinary ability, but similar kind of way that you qualify, which is looking at whether or not you meet, three out of several criteria, aimed at showing that you have exceptional ability, meaning kind of substantial, you've achieved things kind of substantially above others in your field. And for EB2, there's kind of two ways you can use this category. So one is the National Interest Waiver. And we have other presentations where we talk in detail about the National Interest Waiver. So this is where you waive kind of the normal labor market test and PERM process that we're going to talk about today. And instead, what the government focuses on is an endeavor that the person is working on. So you basically say, well, you should waive these other requirements, a requirement of having an employer, a requirement of having the employer do a labor market test, because the person is working on an endeavor that has substantial merit and national importance to the U.S. The person is well positioned to advance their endeavor, and then there's a showing on balance that it is beneficial to the U.S. to waive this normal labor certification requirement. So this category is a great category. It's definitely been used very frequently by entrepreneurs. There was kind of a change in the guidance for how these cases were adjudicated back in 2017 when a new case came out called Matter of Danazar. So as I mentioned, we do have other presentations that go over the National Interest Waiver in more detail, and I would encourage you to check that out if that's something you're potentially interested in. Another way that you can get the green card through the EB2 is through the PERM process. So this is company sponsorship. This is where a U.S. employer is offering you a permanent job in the United States, and they undergo a labor market test to determine whether there's any willing, qualified, and available U.S. workers for the job. So we're going to go over all those details about the PERM and the labor market test in more detail later in the presentation. The EB3, so this is for professionals. That means any jobs that require a U.S. bachelor's degree or equivalent or higher. Skilled workers, which is any job that requires at least 2 years of education, training, or experience. And then unskilled workers, which requires, anything that's less than that 2 years of education, training, or experience. EB4, we won't talk about much today. This is kind of a special immigrant category, covers many different areas, including, kind of religious workers who are applying for a green card. And then there's also EB5, and this is kind of, although it's in the employment-based category, because it does have a tie into employment, it's really an investment-based category where the ability to get the EB5 is based on, investing either $800,000 or $1,050,000, into a new enterprise in the U.S. Or into a regional center, and the creation of kind of 10 full-time jobs. And similar to kind of the National Interest Waiver, we also have other presentations where we go over the EB5 in significantly more detail. So that's kind of the general overview, and we'll talk a little bit more now about the labor certification process. So this is specifically related to the EB2 and the EB3, and you'll often hear it referred to as the PERM. So this is the PERM process, which is the process by which most U.S. companies will sponsor their workers for green cards. So company sponsorship, you can sponsor companies. This is kind of for a future position. So companies kind of can sponsor anyone. You don't have to be in the U.S., although most commonly you are in the U.S. because most employers want to sponsor someone who's actually working for them. Sometimes, is listed here, for example, we have many E2 clients and their spouses can work anywhere. And so sometimes what ends up happening is they end up going through the green card process when their spouse, who's working anywhere is sponsored for the green card. The PERM is a 3-step process. So the first and longest step is the actual PERM, the actual labor market test. The second step is filing Form I-140 with the government. And then the third step is the I-485 or consular processing. That's the actual green card application. So let's walk through these 3 steps. So for the PERM, the first thing you're going to do is draft a job description. And so obviously the job description that the employer wants, for this position is the starting point. But for the PERM, you're only allowed to include the minimum requirements to do the job in a reasonable manner. So most job descriptions are drafted, looking for the ideal candidate, great communicator, great team player, great collaborator. none of those more subjective requirements can be included in a PERM job description. You really have to look at, if you were to hire someone off the street, for this job, what are the absolute minimum qualifications they would have to do this job in a reasonable manner. So often you do have to kind of, look through the application, look through the job description, really see, is it really the case that 10 years of experience are required, or is that more of a nice to have? What has the company done in the past, in terms of hiring? Does every single person on staff have a PhD? So those are the questions you kind of have to be asking when you're drafting this job description. Another thing you have to ask when you're doing the job description is kind of what experience and education does the employee themselves have? Because you can't ask for anything in this job description that the person did not have at the time they were initially hired by the company. So you do have to, when you're drafting the job description, you have to be taking many of those kind of strategic issues into consideration and discussing with the attorney to figure out how do we make sure, we're really including the actual minimum requirements. And then as well, can we, verify that the employee themselves has this, so if we're asking for a bachelor's in business administration, did they have that bachelor's at the time they were hired? So once the job description is finalized, then this is submitted to the Department of Labor to get what's called a prevailing wage. So the Department of Labor will look at the job requirements, at the location of the job, at the job duties, and then they will issue an occupation code, and related to that will be the prevailing wage for that job in that particular location. And that prevailing wage is the minimum salary that the employer must be able to pay the employee at the time they receive the green card. Right now, it's taking about, maybe 6 to 9 months to get prevailing wages issued, by the government. So it is taking quite a long time comparatively to how it's been in the past. Once you have your prevailing wage and the employer is on board and says, yes, this occupation code is fine, this salary is fine, then you can start the actual recruitment process, also known as the labor market test. So this is where the employer is actually going to place advertisements, and there's kind of regulatory requirements about where you have to place the advertisements. So at a minimum, you always have to place them at the state workforce agency for the state you're recruiting in. A notice of filing, which is a physical posting at the physical location, either the job site or the company headquarters. And then also 2 Sunday advertisements, either in the newspaper of general circulation, or one of those can also be in kind of a major trade publication. So there's also, if you're doing this for kind of a professional job or above, an EB2 job, then you also have to include 3 additional mechanisms, 3 additional forms of advertisements. And there's a list of 10 that you can choose from, things like the employer website, a job search website online, TV or radio ads. So some of the, ways in which they advertise that are listed on this list do show that obviously the regulations were drafted, many years ago, so have not really kept pace with maybe the normal way that most people are recruiting. But there are many ones that you actually can use, like posting on the employer website, like posting on a job search website, things like that. So once you get through the actual labor market test, the ads are placed. Now the employer actually has to review resumes. The employer actually has to look at the resumes and see, do any of these applicants seem like they are willing, qualified, and available for these jobs? And if the resume is ambiguous, they should interview the applicant. So, interview everyone. And then if you get to the end of the labor market test, which is usually a 60-day period, and you have not found any willing, qualified, and available U.S. workers, then you can go ahead and file the PERM, file the actual labor certification with the Department of Labor. The PERM is an attestation-based system. This means that they're not asking for any of the documents up front. They're just asking for the labor certification, where the employer attests that they have done certain things. So the employer says, yes, I placed the newspaper advertisements. Yes, I, put stuff up on the employer website. No, we didn't find anyone. And all of that, they're kind of signing under penalty of perjury when they're submitting the labor certification that is accurate. And then they're preparing something called an audit file. So this is all the proof that they actually did everything they attested to in the labor certification. They have the proof of the tear sheets from the newspaper. They have printouts showing, that are date stamped, showing the employer website postings, things like that. So because once the case is submitted, it can either be approved, also called certified, it can be denied, or it can be audited. And if it's audited, then what this means is they then ask you to send the proof that everything you attested to in the labor certification is correct. And so that's where they're going to want to see the tear sheets, the proof of the ads. They do ask often to see the resumes of the people who applied. If there's kind of, evaluation sheets explaining why these people were found to be, not qualified for the job, those should be submitted as well. And there's certain things in the PERM process that can be audit triggers. For example, if you're requiring a foreign language and this is not a job for something like a Spanish teacher, there's a very high standard for proving that you actually need a foreign language because it's obviously a very easy way to eliminate many US workers. So the standard is very high. For example, you not only, if it's not something where it's intrinsically linked to the job, like a Spanish teacher, you have to show that not only does the person spend the majority of their time communicating with people in this other language, but that the people they're communicating with cannot themselves speak English. So it can never be kind of a matter of convenience, unfortunately, for the PERM. They're very, very strict about that. So often it's better to just remove the foreign language requirement unless it's really, really, again, intrinsically linked to the job. Also, other audit triggers, things that are, requirements outside of what's normally required for the occupation. So the Department of Labor has their own kind of internal metrics about what is normal to require in any particular occupation. And if you're asking for more, like if you're asking for, 10 years of experience and a PhD, but they think a bachelor's plus 2 years of experience is normal, that's another reason you may get audited. And you'll have to justify why you need that PhD and 10 years of experience based on real business necessity. So something that really is, fundamental to what the business needs to operate. So in terms of timing, if the case is audited, it can take several more months to be decided. And just to give you an overview of that whole first step, drafting the job description can take maybe a week or two, even up to a couple months. The prevailing wage is taking 6 to 9 months. Recruitment process at a minimum is 60 days, often about 75 because of the extra work to put the audit file together and submit. Once it's submitted, it's taking about 13 to 14 months with the Department of Labor before they issue a decision on the labor certification. So this is a years-long process just for this first step. We do hope that the Department of Labor will start to get some of their processing times down in the coming years. But what we've heard so far is essentially that is not a priority, and that they will, ultimately that the timelines that we're seeing are likely here to stay for the near future. They have not been particularly optimistic that they will get better. So again, when you're planning for the PERM, and we'll talk more about that in future slides, you do need to be thinking about that. What is my underlying visa status? How long do I have? That's something that needs to be planned for. Once you get through this first step, your PERM is now certified. Then you move to the I-140. The nice part about the I-140 is that it can be premium processed, so you can pay the government an additional fee to get an answer within 15 business days. This answer can be an approval, a denial, or request for evidence. If it's a request for evidence, then you submit your evidence, and they'll issue a final decision usually within that 15 business days. For the I-140, a lot less work, basically. At that point, you're submitting proof that the company can pay the prevailing wage. So you're going to have to submit, either audited financial statements, tax returns, or if the company has, over 100 employees, sometimes you can issue a letter from the CFO explaining that the company has the ability to pay the prevailing wage. You can also use other supplementary documents if the person's already working there, earning that wage. You can submit W-2s, things like that. And then as well, you also have to submit proof that the applicant meets all the requirements in the PERM. So if you asked for a master's plus 3 years of experience, they're going to want to see the master's and employer experience letters, documenting the person has that 3 years of experience, that was required by the PERM. So that step can be completed, rather quickly. Then you get to the third step. So this is the green card step. This is either filing the I-485 or doing consular processing. We'll talk about, those two options in more detail in a later slide. Right now, the issue with the green card step is just, is your category current? Is there a visa available in your category? Unfortunately, over the past year or so, we've started to see delays for EB2 and EB3. This has long been the case for people born in India and China, and now it's impacting everyone worldwide. Where there are just delays. So it's generally, more rare these days to get to the green card step and immediately be able to file your green card application, because we are just seeing delays and retrogression in the EB2 and EB3 categories. So again, something to plan for if you do get to that stage and, hey, you can't file your I-485, what are your options? Are you on an H-1B that you can extend? These are all important things to consider. If your timing is current, if you have a priority date, the visa bulletin shows that you can file your I-485, then great, you can go ahead to the third step, file your green card application. Your family members can, any spouse and unmarried children under 21 can join you as dependents. And then that's the last step of filing for your green card. And we'll talk more about, the specifics of that in the other slides. All right, so the green card process. So this is where you've kind of, gotten through the PERM, you've gotten through the I-140, and now you are finally at the stage of getting the green card. And there's two options available. One is called an adjustment of status, and that's done entirely from within the United States. And another is called consular processing, and that is where the green card application is processed at a U.S. consulate abroad, generally in either your country of residence, or if you're living in the U.S., in the country you last resided in prior to moving to the U.S., and you would get your green card that way. I'd say many people going through the PERM process do the adjustment of status. The reason being that generally, if they're doing the PERM process, they're usually employed in the United States. Their spouse and children are usually with them, kind of working or going to school. So the benefit of the I-485 is that once it's filed, you have an ability to remain in the United States. Another large benefit is that once it's filed, you can also file for work and travel authorization, and that applies to everyone who's filed an I-485. So you, your spouse, your children, everybody can file for work and travel authorization along with that adjustment of status application. And then you're allowed to stay here while the petition is pending, even if something happens and you aren't able to extend your underlying status for some reason. So maybe there, there might be some period of time where you don't have that underlying status. It still permits you to stay, and filing early for that work and travel authorization ideally means you can kind of work and travel while you're waiting for this to be processed. At the end of the process, sometimes it's approved just on the papers. Sometimes you have an interview with a USCIS officer who will double check the information in the PERM to make sure that there's still a valid, job offer that meets the requirements in the PERM. And then if you're approved, your green card will be mailed to you, within a couple months. But in terms of consular processing, this option, basically, after the I-140 is approved, the approval is sent to the National Visa Center. The National Visa Center will issue a welcome letter and ask for a bunch of supporting documents to be submitted. So once all of those are submitted, the National Visa Center will review the file. If they determine, okay, we have everything we need, they will then send it to the U.S. consulate in that country where you're residing or where you previously resided. The U.S. consulate is then responsible for scheduling your green card appointment. You attend an interview. If everything gets approved, then they will put an immigrant visa stamp in your passport. And then that's usually valid for 6 months. And during that 6 months, you must enter the United States. Once you enter, that's when you'll be entered as a legal permanent resident. You'll be given something called an I-551 stamp, and then your green card will be mailed to you within a couple months of entering the United States. For consular processing, that's generally just going to be used by people who are either outside the United States for some reason, either their visa expired, something happened, or sometimes, if they're not on an H or an L and they really need to be able to travel constantly, they can't wait for that travel authorization that's required to travel with an adjustment of status, maybe then they'll select consular processing. So there could be different reasons. Always good to talk to your attorney about the various options. All right, so a very common question, who can pay for green card fees? And for many reasons, the policy and the law say that fees related to the PERM process, legal fees and ancillary fees like paying for the advertisements must be paid by the sponsoring employer. They do not want situations where employees are going to the employer and saying, hey, we'll pay you, or we will pay if you will just go through this process for us. So they do want to, they don't want that to be happening. So it is the case that the employer is the one who has to drive the PERM process and pay for it as well. However, once you get to a later stage, so once you get to the I-140 petition, the I-485 or green card petition, at that point, either the employer or employee can pay, the legal fees and the filing fees related to those applications. All right, so dual intent. It's important to know kind of which visas have dual intent. That this is something that's very relevant if you are applying for a green card and you are kind of traveling to the US frequently or living in the US. So there are many non-immigrant visas that do not have dual intent. This means that in order to get this visa, they must show they have a residence abroad, that they don't intend to abandon, and that they do not intend to move to the US permanently. There are some visas that do allow for dual intent. So what we have listed here, the H-1B and the L kind of explicitly in the regulations say, these visas, you're permitted to essentially have a pending green card application, travel freely, not have any issues, with that. The O is listed here. It's kind of a quasi dual intent visa, I would say, this in the sense that the standard for proving non-immigrant intent is much lower. And there's even kind of some favorable language in the Foreign Affairs Manual that talks about, how, merely having an immigrant petition filed does not mean you cannot qualify for an O. Another one I would put here, it's not listed, but it's kind of the E. Another, I'd say, kind of quasi dual intent visa. It's not explicitly dual intent. You absolutely can be denied if they, at the consulate, if they think you're coming to live permanently in the US. That being said, there are some for example, there's a favorable policy memo from USCIS explaining that it's not inconsistent to extend your E2 status and also have a pending adjustment of status. So it is, for those ones, it's less clear. Then there's some where it's very clear that you cannot have the intent to immigrate. So the TN visa, the F1 student visa, these are visas where the standard for proving non-immigrant intent is very high. And at certain stages of the green card process, it would be quite difficult to continue to renew those visas, or you could not travel on those visas after a certain point in your green card process. So, if you are going through the green card process, and for example, you're on a TN and you do have an ability to perhaps switch to an H-1B, it can be a good thing to do, especially if you're in a category where there's delays and now everyone is delayed. The H-1B does have some special kind of, permissions that allow you to extend the status even when there's delays in the green card process. All right, so let's talk about some considerations, when moving from a visa to a green card. I think always really important to look at the big picture when you're undergoing this process, especially, as I mentioned, because it's a multi-year process. So you want to be thinking about, timing. You want to be thinking about your underlying visa status, and talking about that with your employer to figure out what the plan is. As I just mentioned in the previous slide, some visas are going to be harder to extend once an I-140 petition is filed or a green card petition is filed. So for example, if you have an I-140 approved, and you indicated on that I-140 that you were going to adjust status, it's going to be very difficult to get a TN renewed at that point. If the officer raises that question, well, you have an I-140 approved, it says you plan to adjust status. Very unlikely that case is going to be approved, because how can you really show that you actually intend to depart from the United States? There are times where, let's say you have an I-140 approved, but you checked that you're not going to adjust status, you're going to consular process. You can try to make the argument to the officer, I plan to consular process. I do, on this particular entry, I do not have intent to stay permanently. Intent should be assessed at each entry. That's how it's supposed to be assessed. That being said, some officers will not accept that argument. They'll say, look, overall, you plan to adjust, you plan to stay here permanently, therefore I don't think you qualify. So it is something to keep in mind, when your visa expires, and can you time it? For example, if you're going to have an I-140 filed soon and your TN's expiring maybe in 6 months, perhaps you renew it a bit earlier, to avoid issues like that. think about, do you want to adjust status or do you want to get the green card through consular processing? Always important to talk about it with your attorney. If you're like, let's say you're on an E2 employee visa and, that's not, once your adjustment of status is filed, you cannot travel, until you get your travel authorization. And some travel authorizations are taking over a year to be approved. Are you going to be okay staying in the US for that year? You need to have those discussions. Or is it a situation where that's just absolutely not going to work? You have to either travel for work or you have family commitments. In that case, maybe consular processing is a better option for you. That being said, there are some downsides to consular processing. If you're going through consular processing and your underlying visa in the US runs out, you don't have any basis to stay just because you're doing a green card through consular processing. You would have to leave or find another visa to re-enter on. As well, like your spouse and children, same situation. They would, need underlying visas. They couldn't apply for work and travel authorization. So there's definitely pros and cons to each option. You also want to think about your family. Do you have children and you want those children to have green cards? Are your children in danger of aging out? If you're at a stage where your kids are 18, 19, and you want them to have green cards on your application, especially given how long this whole process takes, those are things you need to be thinking about early, just to make sure that they can, join your green card application. All right, so let's talk a little bit about the actual green card interview. So not everyone will go through a green card interview if they're doing an employment-based, application. With USCIS, many times they will waive the interview. Although if you are going to a consulate, you will be interviewed. It'll never be waived. Generally, before your interview, you want to review your I-140, you want to review your PERM, you want to review your green card application, be familiar with all the information that's in there because they can ask you about any of it. You want to organize and print the documents to bring to the interview in a way that you'll be able to easily sort through them to give the officer anything they're asking for. Really closely read that interview notice because it will tell you many things, about what you can and can't bring with you to the interview, what you must bring. They want to see originals of many of the documents. So for example, birth certificates, marriage certificates, you should be bringing those originals and bringing a copy. They should have a copy from, what you previously submitted, but they do also want to see the original and then a copy as well from you. If they don't have it for some reason or they want to keep it. You also have to complete a medical exam as part of the green card application. So if you're doing an adjustment of status in the US, you fill out form I-693, and that goes to a civil surgeon. So somebody in the US who's been qualified to perform these types of medical exams, and they will seal it and send it to USCIS. There used to be issues with it expiring more quickly. Thankfully, kind of due to the delays, the government has taken a more lenient stance at this point. So they're very unlikely that it would expire at this point. If you're doing a consular processing, appointment, then you would get the medical exam done. There's usually an assigned panel physician that the consulate will point you to, and you usually will have to do that, just even sometimes just a couple weeks before your interview. So it's usually very close in time to when you actually have your green card interview. If you're adjusting status in the US, you have to bring proof of your maintenance of status. So if you've ever kind of violated your status in the US, this can sometimes prevent you from adjusting status. Employment-based applicants, thankfully, can take advantage of something called, the benefits under this provision called INA 245K, which kind of allows the government to just look back to your most recent entry as opposed to looking at your entire immigration history. But it is an important thing to discuss with your attorney. Have there ever been status violations? Have you ever accidentally overstayed, even just one day, over your ESTA or over your visa? Did you work past the time you were permitted to? You always want to be upfront about those things, with your attorney so they can prepare you. Some of them may not be issues at all. Some may be issues, but, you won't have a strategy to deal with it, and you don't want it to come up at the interview without being prepared to discuss it. Another thing to do is to meet with your attorney and do a practice interview. So generally your attorney will be able to kind of, go over for you, here's, any concerns, any, trends that they're seeing in the offices. And it's also just a good idea to see, hey, how would I answer this question? You may think, I know the answers, I wrote all this down, no problem. But again, many times a lot of this paperwork has been filled out years prior to you actually even going to this interview. So you do want to just review everything, make sure it's all up to date, and do those practice interviews just so that you're not, so nervous at the interview that you're really able to kind of, explain the information, quickly and easily to the officer. All right, let's talk about porting and changing employers during the green card process. So because it is such a long process, I think often comes up, people are at different places in their careers. They want to know, can I move? Can I take this other promotion? How will this impact my green card application? And porting allows employees to change employers once their I-485 has been pending for at least 180 days. You do have to, like your I-140 does have to eventually be approved or have been approved. And as well, you need to be porting to a job that's in the same or similar occupational classification as the job that was offered to you in kind of the PERM and the I-140. So for example, if you got a PERM approved and, for an accounting manager, and now you want to, open a restaurant and just be an entrepreneur, like I think it might be difficult to argue that these are in the same or a similar occupational classification. You do need to look at things like, what are the job duties? What are the, responsibilities? What normally is required from an education and training perspective? What is the salary? The benefit of porting at this stage is that the new employer does not have to complete a new PERM. They don't have to complete a new I-140. All they have to do is complete an I-485 Supplement J, which is a relatively short form where they indicate, hey, we're offering them a job. Here's what the job is in. Here's the occupational classification, and then include the argument as to why it should be considered same or similar occupational classification as the other job. And it doesn't need to be a new employer. Sometimes maybe you got your PERM approved as a finance analyst at this one company, but now, it's 6 years later. And they, over this period of time, now they want you to be a finance manager. So the new employer can submit that porting request on the I-485 Supplement J. You can also port to self-employment, but it might be difficult, again, depending on what type of job, the PERM was approved for. Prior to the filing of the I-485, though, like let's say your I-485 isn't filed, maybe your PERM is approved, but your I-140 hasn't even been filed yet, and now you go to a new employer. Unfortunately, you really don't take any benefits from the PERM at that point. The new employer has to file a new PERM, a new I-140. Even if you get to the stage where your I-140 is approved, you do get one benefit, which is you get to keep the priority date of the approved I-140, but the new employer would still have to file their own PERM. The new employer would still have to file their own I-140. The benefit you get is that, you can probably apply for the green card sooner because your priority date, will already be current. So those are, kind of things to keep in mind, is that portability, while a great benefit, really only comes into play when you're at the very end of the green card process, when you already have a green card I-485 application filed and it has been pending for 180 days. Notably, porting is only available based on this I-485. If you're going through consular processing, you're not going to be able to take advantage of portability. All right, another very common question: can you change employers after you get your green card? So when you obtain your employment-based green card, you're making a good faith attestation that you intend to continue working for this company permanently. The company is doing the same. They're making an attestation that they intend to, employ you in this permanent role. That being said, once you have your green card, you are not tied to the employer. Hypothetically, yes, you can get your green card and quit the next day. That being said, if you eventually plan to naturalize, if you eventually plan to apply for U.S. citizenship, they often will look back at how you obtained your green card in the first place. And if they look back and they feel that there was fraud or misrepresentation, because, hey, you got this green card with this company and then you quit the next day and then you start, you worked in a completely different field and, what was going on with that. That can raise issues. And hypothetically, they could look back. And if they felt there was fraud or misrepresentation in the actual green card application, they could take steps to start to rescind that. So there could be some very significant, consequences. So while it is, again, not required that you stay with the employer, it is a good idea to continue working for that employer for long enough that it's clear that you did not make any, misrepresentations. That, it's one thing if you say, well, yes, I was working for the employer, and then, 2 months later, my spouse got an amazing job opportunity in another state and we had to move and I couldn't, so there can be reasons, right? Like, it's once you have that green card, you aren't tied to the employer. But it is something to consider in terms of, your immigration record. And if you do plan to live in the US, long term and eventually become a US citizen, it is something that could come up. Additionally, sometimes employers will have certain, things in their contracts about, if you leave within a certain time frame. Maybe they were paying for the I-140 and the I-485, and maybe if you leave, they ask that you pay that back. So there are certain things that kind of can come up if you do leave, very quickly after you're getting your green card. That being said, you are permitted to do so, even if it's not really recommended.
Perfect. Thank you very much, Kelly, for that outstanding and very thorough information. We've received one question, and I will just remind our audience, if you do have questions, send those in now. We'd be happy to respond to those. So the question is related to what you were talking about regarding portability to some degree. So this person is currently in H-1B status. Their employer submitted their PERM application in May of 2024, so just a few months ago, 5 months ago. They expect that will be approved in June 2025. If they are terminated from the job this year, can the employer, I presume a new employer, continue with the process, filing the I-140 and I-485?
Yeah, so I mean, if you're fired from if you're fired from the job that you're at that filed the perm for you, and there's a new employer, the new employer doesn't get any benefit from that previous perm being filed, nor do you. So it's like the new employer would just have to file their own perm, their own I-140 and I-485. The new employer cannot take on the old perm. If you're talking about the same employer, assuming that the same employer both both fired you and is willing to proceed with the petition, it is possible, yes, because the perm is for a future looking position, right? So you don't actually have to be working for the company. So if they said, hey, we're firing you for now, but yes, we're still willing to continue with this process, and in the future, if this is approved, we will hire you into this role, that's fine. That is something that is permitted, but the employer themselves obviously needs to be willing to do it.
Great. Thank you, Kelly. So is it possible to submit an NIW EB2, so an EB2 National Interest Waiver application entirely from outside the US, or is it better to first work and reside in the US and submit the application from within the US?
So it is possible to submit the I-140 for the NIW EB2 from completely outside the US. You are not required to be in the United States to file that. I think that, oftentimes it is better if you're in the United States, because if you're working on an endeavor that has substantial merit and national importance, and you've already done work in the United States that speaks to that endeavor, it often is very favorable for the application. But it's a very fact-specific inquiry. So if you do have kind of, want to have a more detailed conversation about an EB2 or NIW, I'd encourage you to set up a consultation.
Perfect. Great. Well, Kelly, thank you very much for taking the time to share your expertise to our audience. Thank you for the great questions. Please do keep an eye out for that follow-up email we'll send to you. We hope to see you on future webinars, and check out our blog and our YouTube channel in the meantime. Everyone stay well. We look forward to seeing you soon.
Thank you.